Hello friends, I welcome you all to today's lecture on marriage under Hindu law. The aim of this lecture is to explain the nature and scope of marriage. It is considered a sacramental union between a male and female. According to Munnu, marriage amongst Hindus is a religious obligation and both male as well as female is incomplete without performing marriage. The marriage amongst Hindus in terms of classical approach is a pure religious and sacramental affair. It is an eternal union between a male and female, not only here but also in the world hereafter. According to Dharma Shastra, every male is supposed to marry in order to beget a son for discharging debts of his ancestors, besides performing other religious duties. According to the classical approach, no marriage can be possible without performance of sacred rites and ceremonies. Marriage, according to Hindu law, is a holy sacrament. Polygamy was permitted in Hindu society but not polyandry. Legislation relating to Hindu marriage began from the year 1829 when sati was abolished by law and declared an offence at the instance of Raja Ram Mohan Roy. Hindu Marriage Act 1955. The Act treats marriage as a contractual union between a male and female, which is dissoluble in its nature. Thus, the consent and mental condition of the parties, which had no role prior to this Act, plays an important role in the formation of marriage contract. It recognizes the circumstances under which a marriage can be treated as void and voidable, thus consequently making it a dissoluble tie. In brief, the sacramental character of Hindu marriage is no more ostensibly in existence. Conditions of a Hindu marriage. The Act is a self-contained code in the matters enumerated under this Act regarding any matter of Hindu marriage. Section 5 of the Act provides that a marriage may be solemnized between any two Hindus if the following conditions are fulfilled. Neither party having a living spouse. Under the Hindu Marriage Act 1955, neither polygamy nor polyandry is allowed. The special feature of this act is the provision of monogamy instead of polygamy. So, any marriage solemnized after the commencement of this act is absolutely null and void if it contravened any conditions stipulated therein, including the condition of monogamy. Neither a Hindu male nor a female can marry during the lifetime of his first wife or her first husband. A person should be a bachelor, widower or widow or divorced at the time of marriage. A marriage which contravenes any condition laid down under the Act shall be liable to be declared null and void in terms of Section 11 of the Hindu Marriage Act 1955 on the petition presented to the court by any party thereto, even if the parties have lived together as husband and wife and have even children born thereto. A person who marries in violation of this condition, that is monogamy, is liable for the offence of bigamy, which is punishable under sections 494 and 495 of the Indian Penal Code 1860. Competence to contract marriage. Under Hindu law as laid down by old texts and as administered before the commencement of this act, a marriage of a lunatic or idiot was valid under the traditional Hindu law. After the commencement of Hindu Marriage Act 1955, Section 5, Clause 2 provided for idiocy or lunacy at the time of marriage as a legal disability for contracting a valid marriage. However, the courts took rather a narrow interpretation of the term lunacy or idiocy at the time of marriage to lay down that any subsequent lunacy would not affect the validity of the marriage. It will be appropriate to quote the observation of Punjab and Haryana High Court delivered in Munshivar Datta Vashist versus Indra Kumari in this respect. An attack of insanity, where it amounts to mania or schizophrenia, if comes after the marriage, will not furnish a ground for annulling the marriage. What is momentous, therefore, is the mental condition at the time of marriage, which is the crucial time for determining the question of annulment. Keeping judicial decisions of above nature in mind, the entire law relating to mental capacity under the Act was modified in 1976 and replaced by the present provision. Clause A of subsection 1st of Section 5 of the Act speaks of unsoundness of mind, but not every kind of unsoundness of mind. It is restricted to that type of unsoundness of mind as may in law render the potent incapable of giving a consent which law can recognize. Similarly, clause B indicates that the mental disorder should have lasted for some length of time. It does not, however, define the term mental order, but simply says that the mental disorder must be either of such a kind or to such an extent as to make the patient unfit for marriage and procreation of children. Under this section, a decree of annulment may be granted if it is proved inter alia that spouse was of unsound mind or was suffering from a mental disorder of such a kind or such an extent as to render him unfit for marriage and procreation of children. Cancellation of marriage, however, is being a drastic relief. The onus of proof lies heavily on the petitioner to prove the case. Clause C of subsection 1st of section 5 deals with recurrent attacks of insanity or epilepsy as the ground for annulment of marriage. But again, the terms of insanity or epilepsy have not been defined. Whether a person has in fact been subject to recurrent attacks of insanity or epilepsy will have to be ascertained by the court with the aid of medical opinion and other cogent evidence. Age of majority of the parties. The Hindu Marriage Act, being a post-independence statute passed in the background of equality, gender justice and reformation, had to pay for such policy and procedure, eliminating thereby all types of unjust rituals, irrational practices and ill-founded dogmas. The social evil of child marriage, being largely prevalent, had to be eradicated as a sequel to these reformations. In 1929, an attempt was made to prescribe 15 as the maximum age for girls and 18 for the boys. However, in 1976, this condition was modified and marriage age was raised to 18 and 21 respectively. Though the Act prescribes a minimum age as one of the conditions for a marriage, however, marriage in breach of this provision is neither void nor voidable. It is only punishable under Section 18 of the Act and under the Child Marriage Restraint Act 1929 as amended in 1978. In V. Mallikarjunaiah versus H.C. Gaurama, the husband sought declaration of marriage as void on the ground that he had not completed the age of 21 years at the time of marriage. The issue whether such marriage was valid, void or voidable was discussed at great length. The trial judge dismissed the husband's petition as it held that there was no cause of action. In appeal, the arguments raised on behalf of the husband were that Section 11, which provides the grounds for void marriage, should be read with Section 5, and any marriage in breach of conditions laid down in Section 5 should be declared as null and void. It was further contended that the law should not be so interpreted as to defeat its provisions. On the other hand, for the wife, it was contended that the legislature specially excluded Section 5, subsection 3 from the purview of Section 11, Section 12 and Section 13, and this exclusion was neither by accident nor by oversight, but deliberate. After detailed arguments, the court came to the conclusion that the law does seek to discourage marriage of underage boys and girls, but not to the extent of making them void or voidable. The socio-cultural conditions of the society and the consequences of invalidating such marriage on the girls especially were highlighted by the court. It observed, having regard to the strata in which marriages were likely to take place, the legislature was cautious of the fact that such provision should not have the result of rendering a large number of girls or young women virtually unmarried or to the destitution. The only security that a girl or woman in such a situation is entitled to is within the framework of the marriage, and if that marriage can be loosely undone or if it is not recognized by the law, it would result in disastrous social consequences, which is the only reason why this section was specifically excluded from Section 11 and 12 of the Act. Though such exclusion does not give a license for underage marriage, since they are punishable under Section 18 of the Act, the court suggested that in view of the rampancy of the practice, there is a need to provide for harsher penalties, particularly for those responsible for this. In Gajar Naran Bura versus Kanbi Kumarbai Pratap, the husband sought to defeat the wife's application for maintenance on the ground that marriage was in violation of the age requirement prescribed by the Act and hence void. The trial court dismissed the wife's claim, but the lower appellate court granted her maintenance. In second appeal, the Gujarat High Court held that child marriage by itself is not invalid nor a nullity unless there has been fraud or force in the solemnization of such marriage, in which case provisions of section 12, subsection 1st clause C of the Act would be attracted. Degrees of prohibited relationship. Hindu Marriage Act 1955 has more or less retained the traditional relationship within the degrees of prohibited relationships to marriage. Thus, the Act clearly provides that any two persons who are major and not within the prohibited degrees of relationship enumerated under Section 3 of the Act shall be eligible for contracting a valid marriage. It may not be out of place to make it clear that persons mean Hindu as defined under the Act. Now the question arises as to what does the term degrees of prohibited relationship mean? Section 3 clause G of the Act lays down that two persons are said to be within the degrees of prohibited relationship if one is a lineal ascendant of the other, or if one was the wife or husband of a lineal ascendant or descendant of the other, or if one was the wife of the brother or of the father's or mother's brother, or of the grandfather's or grandmother's brother, or if two are brother and sister, uncle and niece, aunt and nephew, or children of sister and brother, or of two brothers or of two sisters. The above prohibited relationships include relationship through blood and adoption. Blood relationship includes all of its three kinds, namely full, half and uterine. It also includes illegitimate blood relationship. Any marriage solemnized after the commencement of Hindu Marriage Act 1955 shall be null and void if it contravenes the condition regarding prohibited degrees. A person who procures a marriage of himself or herself in contravention of this condition shall be punishable with simple imprisonment, which may extend to 1 month, with fine or with both. However, if a custom permits a marriage between two persons within the degrees of prohibited relationship, then such marriage is valid. Sipinda relationship. Another important condition for valid marriage is that the parties should not be sipindas of each other unless permitted under custom or usage governing the parties. The term sipinda is a derivative of the word pinda, which means the same. There is divergence of opinion between two schools of Hindu law regarding the real meaning of the term sipinda. According to Mitakshara law, sipinda means of the same blood. So anyone who is having common blood shall be treated to be a sipinda. As against this, Daya-Bhaga law treats sipinda as an offering made to ancestors and thereby demonstrate nearness to their ancestors by performing pindadan. While as Mitakshara jurists have limited the sipinda relationship up to 7th degree on the father's side and 5th degree on the mother's side. The Daya-Bhaga law recognizes only 6 ancestors on father's side and 4 on the mother's side, constituting the sipindas. The Hindu Marriage Act has made suitable change in the classical approach by limiting the sipinda relationship by 2 degrees on either side. Section 3 clause F defines sipinda relationship with reference to any person extends as far as the third generation inclusive in the line of ascent through the mother, and fifth inclusive in the line of ascent through the father, the line being traced upwards in each case from the person concerned who is to be counted as the first generation. Two persons are said to be sipindas of each other if one is a lineal ascendant of the other within the limits of sipinda relationship, or if they have a common lineal ascendant that is within the limits of sipinda relationship with reference to each of them. Any marriage solemnized after the commencement of Hindu Marriage Act 1955 shall be null and void if it contravenes the Sapinda relationship condition, and any person who procures a marriage of himself or herself shall be punished with simple imprisonment which may extend to 1 month, or with fine, or with both. Consent of guardian of a minor. While the bride has not completed the age of 18 years, the consent of her guardian has to be obtained before the solemnization of the marriage. This provision has almost become redundant in view of the fact that after the enactment of the Child Marriage Restraint Act, no minor can be given in marriage without his or her consent and before attaining the age of majority stipulated thereunder. Ceremonies for Hindu marriage. Section 7 of the Hindu Marriage Act 1955 provides, a Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party thereto. While such rites and ceremonies include the Satpadi, that is taking of 7 steps by the bridegroom and the bride jointly before the sacred fire, the marriage becomes complete and binding when the 7th step is taken. The word may gives an option only regarding the kind of ceremony with which the marriage is to be solemnized. The courts have all along taken the view that necessary ceremonies as applicable to the parties ought to be performed to validate a marriage. In Lakshman Singh versus Keshar Bai, it was observed that necessary ceremonies, shastric or customary, whichever are prevalent on the side of bride or bridegroom, must be performed, otherwise marriage will not be valid. As a conclusion, the marriage amongst Hindus in terms of classical approach is pure religious and sacramental affair. Thus the matters regarding which provision has been made in the Act are no more governed by the old Hindu law. However, the matters regarding which no provision has been made in the Act and which are not inconsistent therewith will continue to be governed by the old Hindu law. The enactment has brought uniformity of law for all sections of Hindus. With this, I conclude this lecture. Hope you have understood fully. Thank you.